Never again shall they be ruled by a woman. My Lady Chief Justice, we still have some people within our own society, particularly men chauvinists, who seem to think that you may turn out to be like a Wangua or Makeri. They fear that you may probably not be someone who will listen to them. But we who have known you for a long time, we know that there's no way you can become Wangua or Makeri. You will treat men and women gradually. The Honorable Lady Chief Justice, yourself and your deputy, you join Club of Great Women of Kenya. You join women like Mora of Kisii, who fought the colonialists very energetically. Lately, the two of you join great women like Professor Wangari Maathai, whom I had the privilege to appear for in court, to represent her in many cases, a very bold woman who was tortured, but she stood firm, and she deserved to get the rank of, to get the prize of a Nobel Prize as the first African woman in this country. My Lady Chief Justice, I would like to mention one or two people who have not been mentioned at all. I think that it's appropriate that we should mention our first Chief Attorney General, the Honorable Charles Njonjo. He had his own shortcomings, but it's not appropriate for us, according to the African custom, to emphasize the shortcomings that he had at all. But he was our first Attorney General, and he was Attorney General for about 21 years. But one thing that he stood for, and which we shall remain grateful to him as a community and as a country, in that he was able to preserve and stand for the sovereignty of our country. At that time, the country was going through a very difficult time. We had coups all over Africa. We had people who wanted to secede from the Republic of Kenya and go elsewhere. Some of our neighboring countries were making claims to our borders and so on. But he stood firm, and he was able to protect the executive, to advise the executive, and we were able to preserve the sovereignty of the country. We must remain grateful to him. I would also like to mention two other people. I mentioned Zamba Kitonga, who was one of the first chairman of the Constitutional Review, a great Kenyan of impeccable character and integrity, but it's unfortunate that he is no longer with us at all. I would also like to mention Professor Yash Gai, a very great son of Kenya. He is the one who has developed constitutional and public jurisprudence in this country, perhaps more than anybody else. We stand grateful to him. He is still alive. I haven't been able to meet him for a long time, but I'm told that he's in Kenya. He is living in Nairobi with his lovely wife, Professor Cottrell. Now, if you may permit me to come to why we are here this morning. My lady, I will repeat what I said on my opening words before the Court of Appeal. I will repeat to you, as a country, we have been extremely unfortunate in that we have had a poor crop of politicians. The first crop of politicians that we had in the country measured very favorably with world leaders, with world politicians like Gandhi, like Kwame Nkrumah, like Nehru, and others. That was Mzee Jomo Kenyatta and his colleagues in the first government, people who fought for independence. They had grand ideals for this country. But then thereafter, after their demise, we have now current politicians, and there's very little really to admire them for. Recently, I said in Court of Appeal that most of them, you get the impression that they are job seekers, they are office seekers. And they come up with things like amendment of the Constitution because they want to continue to be in power. They don't seem to have really much that they can offer the country. Now, I would like to emphasize one thing, my Lady Chief Justice. To look after a country, you must have a creative mind. That is very important. You must have a creative mind where you are able to come up with ideas that can be able to rule the country. And whenever you have a poor politician who runs short of ideas, the immediate thing that he will tell you is that let us amend the Constitution. And that is what precisely happened with the first Constitution. It was amended many, many times, to such an extent that it ceased to be a Constitution. It was not better than toilet paper at all. We were not proud of it at all. And some of the problems we have at the moment is because of the frivolous amendments of that Constitution that was now overthrown by the 2010 Constitution. Now, there has been a lot of talk about basic structures. I do not wish to dwell very much to go into what has already been said, my very able learned friend. And at this stage, probably I should mention my able learned friend, Mr. Harvey. I thought he did a very good job. He opened the case very well, and he exhibited the impression that he's a person who's very well read and has read the brief very well. I do not wish then to go into a lot of details at all. And I may point out at this stage, my Lady Chief Justice, that should I try to repeat myself, I would have no objection if you tell me that, Hamino, we have already heard that, move on to something else. Now, I will refer you to the Constitution of Kenya straight away. May I refer you to the Preamble? The Preamble of the Constitution of Kenya is very important when you are considering the question of basic structures. Acknowledging the supremacy of the Almighty God of all creations. My Lady, may I pause there? That first sentence, acknowledging the supremacy of the Almighty God of all creation. My Lady, it shows that there is something above the Constitution, written Constitution of Kenya. It brings in the concept of natural law. And if any amendment or any proposed amendment is against the supremacy of the Constitution, the supremacy of the Almighty God, that amendment must be struck out. It's a higher law more than the Constitution or the other written words that we find in the Constitution. Honoring those who heroically struggle to bring freedom and justice to our land. Again, that reminds us very emphatically that we should not forget the history that this country went through at all. Dirty and rotten history of assassinations, people having to fly from this country, of the Nyayo era. And at this stage, I may probably My Lady Chief Justice, I've got the book here, a sad book. We lived to tell the Nyayo story. I am almost crying. These were people who were tortured, who slept in cells with water. Some of them thereafter died immediately. They were not fortunate to live as long as Amin was living at all. They could probably have lived much longer. We have them here. It shows the history of Kenya. My lady, we should never forget the history of this country. And I'm afraid to say, my lady, we still have elements within our society, within the Kenyan society. If you do not stand firm and strong, they would like to take us back to those days of the Nyayo era. We had people leading the country, great minds. My contemporary at the Lions Just School, Nganga Tiongo, living in America. He cannot live in this country at all. Alamin Mazrui, living in America. He cannot live in this country at all. In brief, I'm making a point to you that the constitution that we have at the moment was deliberately made unamendable. Was deliberately made unamendable. And I refer you in this case to the book called Constitutional Amendments, Constitutional Amendment by Rosenai. I refer you to page 258 of that book. Page 258 of that book. It mentions Kenya, and it says Articles 255 to 257, different procedures for different provisions. The heading is that these are provisions that are, although they are provided for in the Constitution, but they do not have the force of law at all because they cannot be properly interpreted by the courts at all. So I'm taking the position, my Lady Chief Justice, that the Kenyan Constitution, if you read it very carefully, the entire Constitution, it seems to have been drafted in such a manner that, strictly speaking, this Constitution is not amendable at all. The idea being that if you allow people to amend it, then we shall, within a short time, not have a constitution at all. Now, if I may now take the court to the preamble again. Proud of our ethnic, cultural, religious diversity, and determined to live in peace and unity as one indivisible sovereign nation. My Lady Chief Justice, that is where one of our problems we have. That is one of the problems we have as our country, that I have. The book, the title of it is Making Constitutions in Deeply Divided Societies. Making Constitutions in Deeply Divided Societies, by a lady called Hannah Lana. Making Constitutions in Deeply Divided Societies, by a lady called Hannah. And I will read only, with your permission, I read only 2 words, or 3 sentences. Nearly 190 national constitutions are in force today. More than half of them have been written or rewritten in the past 3 decades. Many of these constitutions begin with some versions of the famous 4 words, "We the people." Now, my Lady Chief Justice, we the people, are we really a cohesive society? We are tribes. Our political parties are tribal political parties. They share jobs in advance. Jobs are given according to what tribe you are. whether it should be that, it should be that, and so on. We are already tribes, so we have a problem. We cannot speak of a society or a community that is cohesive at all. We are very far from that. And we are only kept together as a nation by the 2010 Constitution, amended some sections, parts of that Constitution. The inevitable result will be chaos in the streets of Nairobi, chaos in the streets of Mombasa, chaos in our provinces. We need to nurse it. We need to nurse our Constitution so that we give it opportunity to be fully implemented and to grow. In other words, my lady, what you have to do when you are making any decision, you must exercise restraint. You cannot just go out and allow politicians to say they want to amend this Constitution at all. First, to make it was a big job, was a very difficult job. Now it's better that we keep it as it is. There are some individuals, for instance, who have come up with a bill. They suggest that we should have a president and deputy president, and then prime minister, and several other positions. These are intended to create jobs for people whom you can actually call tribal leaders in the country. And the small tribes will be discriminated against. The majority will discriminate small tribes of the country. Let us not buy the idea when they tell us that we shall have a more stable society, a more cohesive society, if we implement we implement the bill by giving jobs to certain individuals. We shall be entrenching tribalism, ethnicity in our society, where you have only certain communities that have been given certain jobs or certain positions in looking after the country. Permit me to go further. There is a respect for environment, which is a good idea, and there is a committed to nurturing and protecting the well-being of the individual, the family, communities, and the nation, which we stand for, recognizing the aspirations of Kenyans for a government based on the essential values of human dignity, equality, freedom, democracy, and so on, and then exercising our sovereign and inalienable right to determine the form of governance and so on. The point is that this preamble is actually like the ideology that the country stands for. In interpreting Kasvananda case in India, their lordships, the judges, relied on the preamble to the Indian Constitution. The preamble to our Constitution is very important. We cannot afford to ignore it. And in this regard, may I refer you to the authority that supports this submission that I'm making to you. Sorry, my lady, I cannot find the book very quickly, but I have a book that has been written by one of the authors in which he is emphasizing that the preamble can be relied upon in interpreting the Constitution. I may I found it, man. Hidden itself. I'm referring to a book called Interpreting Constitution, a Comparative Study. Interpreting Constitution, a Comparative Study, edited by Jeffrey Goldsworth. Interpreting Constitutions, a Comparative Study, edited by Jeffrey Goldsworth. And it says this at page 247. The court, that is the Indian court, the court has used the preamble of the Constitution as a basis for articulating the basic structures of the Constitution. That is a preamble. The preamble, the court has used the preamble of the Constitution as a basis for articulating the basic structure of the Constitution. And may I refer to the same book before I lose it again, at page 265. And with your permission, let me read it to the Honorable Court. Despite its shortcomings, that's the Indian Supreme Court, the court can be proud of its record. The main responsibility for defending constitutionalism in India has fallen on non-elected authorities. May I pause there? There are some individuals in the streets of Nairobi who may say, why should the judges have such power? Why should the Supreme Court have such power? Why should the Court of Appeal have such power? Why should the High Court have such power? Because they are not elected members of society. But the learned author is telling us this, that the power to amend, the power to guard and look after the Constitution in India is no longer with the elected members. It is no longer with elected members. May I again read this provision very shortly. Despite its shortcomings, the court can be proud of its record. The main responsibility for defending constitutionalism in India has fallen on non-elected authorities, such as President. President of India is not elected, the Honorable Chief Justice. The Election Commission, the National Human Rights Commission, and the judiciary. So the point I wish to emphasize to you is that you do not have to be shy to make decisions at all. The fact that you are not elected people is neither here nor there. You are a powerful institution that should protect our 2010 Constitution. It goes on, the Supreme Court, as the apex court with the power of judicial review over all other authorities, has shouldered the heaviest burden. Its assumption of power to review constitutional amendments, which our law also provides for. You can review the constitutional amendments, has made the most powerful court in the world. My Lady Chief Justice, we want this Supreme Court to be the most powerful court in the world, to be the most powerful court in East Africa, to be the most powerful. May I again continue? Has shouldered the heaviest burden. Its assumption of power to review constitutional amendments has made it the most powerful court in the world. It has evolved from a timid positivist court into a very activist one. Its more prominent policy-making role has stemmed from its expansive interpretations of fundamental rights and directive principles, and its liberalization of procedural rules governing access to justice. Through its development of that role, the court has earned widespread legitimacy, which has helped to ensure that its decisions have been generally obeyed. My Lady Chief Justice, now that you are sitting on that chair of power, we are asking you respectfully that you give interpretations to the law, to give it interpretation to the Constitution, so that this case or this Constitution or this court becomes the most powerful court in this country and outside this country. My lady, I've just been reminded by my junior, Valentine Khaminwa, that I've only 7 minutes to go. May I say with respect, I know that you have been giving people 15 minutes or 10 minutes or so on, but if I may say with tremendous respect, I usually think that I have a creative mind, and I can say quite a bit, not for selfish reasons, but I can say quite a bit that can help in shaping the jurisprudence of the country. I ask you very respectfully that you extend my time, that you do not give me only 15 minutes or 20 minutes to address you at all. You give me a little bit longer than that. I think that I can make a contribution to the jurisprudence of this country. My lady, you remember I talked about the sad history of this country. May I make a reference to 2 books only? I would refer you to a book called Kenya, A History Since Independence by Charles Hornsby. Kenya, A History Since Independence by Charles Hornsby. Charles Hornsby, my lady, has got a Doctor of Philosophy in Kenyan politics. And in his book, he sets out the serious shortcomings that the society, the country has had. I will refer you also to another book, which is written by Daniel Branch, Kenya, Between Hope and Despair. The title tells you a lot. Between Hope and Despair, between 1963 and 2020. No wonder that our former president, Kibaki, a very learned president, when he was being sworn in, he said that he was inheriting a seed that had caused misrule for a number of years in the country. I will also refer you to Article 2 of the Constitution, supremacy of this Constitution. Supremacy of this Constitution. It's my humble submission that just from these 4 words, supremacy of this Constitution, one can state that the basic principle applies in Kenya. Supremacy of this Constitution. What that means that anything that is in conflict with the supremacy of the Constitution must be declared void, null and void. And it's significant, my lady Chief Justice, that Article 2.5, the general principles of international law shall form part of the law of Kenya. International law also limits the power to amend. My lady Chief Justice, I refer you to Article 5, Territory of Kenya. I was reading the submission of our very able Solicitor General that he gave this court. And according to him, the basic structural doctrine does not apply. I have known the Solicitor General for a long time. As a bar, as a privilege of arguing case against one another, and I found him to be a very able lawyer. But this time I must say to him that when he says that the basic principle does not apply in Kenya, he is saying so with his tongue in the cheek. He is not being sincere. He is not being honest. My Lady Chief Justice, if I may remind you, we have problems with the maritime boundaries down at the coast. And the Kenyan authorities, on advice of the Solicitor General and on advice of the Attorney General, told the ICJ, the International Court of Justice, that this matter cannot be adjudicated upon at all. They were right. I supported them. And you know, they were relying on the basic principle which is contained in this court, in this constitution. And Article 5 says, Kenya consists of the territory and territorial waters comprising Kenya on the effective date, and any additional territory and territorial waters as defined by an act of parliament. This is an issue that any court cannot sit and make a determination upon at all. And they were right. It is a basic principle that the Solicitor General advanced to the ICJ or advanced to the lawyers that let us not go to ICJ. We shall be wasting our time because this is a matter that cannot be litigated upon at all. May I refer you again, very respectfully, to Article 143, protection from legal proceedings. That is the President. Protection from legal proceedings by the from legal proceedings. This with respect to President. Article 143, Article 2. Civil proceedings shall not be instituted in any court against the President or the person performing the functions of that office during their tenure of office in respect of anything done or not done in the exercise of their powers under the Constitution. It is my humble submission, my lords, that if the President is not acting within the law and is not acting within the Constitution, it is actionable. He will be doing so at travers the Constitution. And
Dr. Kamino, how much more time do you need? Your time is up, and we have a lot more work to do. Could we give you another 10 minutes?
Oh, 10 minutes. Okay, I'm most grateful.
10 minutes?
I'm most grateful. 10 minutes, I'll finish.
Yes.
My lady, I'll finish. Yeah. And then, my lady, I refer you to Article 259, which deals with the construing this Constitution. Yeah. Particularly Article 3, which says, 259.3, every provision of this code shall be construed according to the doctrine of interpretation and so on. That's so much I can do. My lady, may I draw the court to this provision, the Article 38. Article 38 of the ICJ. Article 38 of the ICJ. According to this article, Article 38, my lady, provides, Article 38 of the ICJ provides for the sources of international law, and it is my humble submission that the sources of international law include decisions made by national courts. And the national courts in this particular principle of basic structure have held in Asia, in Africa, and in America that the basic principle applies. Basic principle is therefore no longer debatable, is a source of international law, and it can be enforced by virtue of Article 38 of the ICJ. I'm quoting this from groundless principles of public international law. I would refer you to a book called The Changing Structure of International Law by Professor Friedman, Professor of International Law at Columbia University. And in his book, at page 159, he refers to international constitutional law. International constitutional law. International constitutional law, my lady, involves cases like the basic fractures, the Casavananda case. Regarding the misrule, I'm relying on the book authority called Democracy by Condoleezza Rice, which is to be found at page 216 to 217, where he emphasizes, or where he sets out what former President Kibaki said when he was being sworn in. Already, we have filed authorities, we have filed written submissions, we rely on the legal authorities, we rely on the submissions that we have filed. And I invite you very respectfully that you uphold the decision of the Court of Appeal, you uphold the decision of the High Court, and you hold that basic principles apply and the President does not enjoy immunity at all. With those remarks, I say to you, thank you very much. I'm sorry I've had little time. I would have liked to talk more, but out of respect for the court, I should obey what the court says. Thank you very much.
Thank you very much, Dr. Kaminwa. We also celebrate you and honor you for the work you have done in the profession. You have mentored many, many lawyers, and you have really defended the Constitution and the rule of law all your years. And for us, you remain our symbol of unity in the legal profession. So thank you very much. We appreciate you also. So this time now, I will ask my colleagues to seek clarification from the submissions so far made by the third appellant and all the respondents who are opposing the first and second appeal. Judge Ouko.
Thank you, Judge President. Thank you, Counsel. I've got a couple of questions and clarifications. I'll start with Mr. Harvey. Once again, on basic principle, basic structure, would you say that the holdings of both the High Court and the Court of Appeal give sufficient guidance to the citizens of this country on how to go about this? Does it tell them what provisions are secured, which provisions will not offend the basic structure? Because looking at the decision by the High Court, it seems that from the preamble to all the 18 chapters, including the 6 schedules, are no-go zones. The Court of Appeal affirming them, but with a bit of modification, seem to say that the entire Constitution actually says the Constitution itself and all that it contains. Same court seems to suggest that yes, there is basic structure, but it's codified or enacted in 255(1). and that for you to touch it, you must go through some 4 sequential steps. But these steps are not spelled out by the court. So the question is, have we guided as the judiciary, as courts, the citizenry sufficiently to know how to go about this in future? The second one is related to the 4 sequential steps. What is the basis of this? Is it part of the procedure contained in Article 255, 1 to 11? Is that can we find it there, these 4 sequential steps, or is it something we picked from somewhere else? That would be it for Mr. Harvey. My next question is to Ms. Kituku for Muhuri. The attention of the High Court, and I believe that of the Court of Appeal, was drawn to the fact that there are certain actions that had been taken by IEBC by the time they were being told that they were not properly constituted. For instance, there were 30 by-elections that had taken place, and I dare add that even the election of the President of the Court of Appeal was done during this period. What is the status in law of these actions that were taken when you said the commission was not properly constituted? My lady, that's all from me.
My first question goes to Mr. Murare Omoke, as well as I think Ms. Angawa and perhaps Ms. Kituku, who talked about the quorum and the issue of minimum and maximum membership in the commission. In the Constitution, there are express provisions for quorum, for Parliament, for the impeachment of the President, for the Supreme Court, and when you come to the chapter on the counties, the legislation for counties must provide for quorum. Then there are other institutions or agencies like Cabinet, like the commissions, where they prescribe a minimum and a maximum. This is different from quorum. You seem to suggest that quorum ought to be read in to the Constitution, whether or not there is legislation. My question then would be, for what purpose then has the Constitution stipulated a minimum and a maximum? What is the purpose of putting in a minimum or a maximum? What do those words mean? My second question goes to Mr. Angoya. You know that this matter has come to us as an appeal as of right. And I wasn't sure that, it seems to me that you're suggesting that where there is a question of constitutional interpretation, which is pegged on the actions of a state agency or body, then we, on second appeal, would be bound by the rule of factual limitation on a constitutional question, constitutional interpretation. I just wanted you to clarify that. Finally, to Ms. Kituku, you've suggested that the IEBC, the public participation was not enough, the use of the website. What would you be suggesting could be a method that the IEBC could use in order to reach the Kenyans who you say were not reached? Secondly, I wasn't clear. You talked about evidence that there is no participation in county assemblies. Then you said that the county assemblies have not participated in this case. I was hoping that you could perhaps point to us on record the evidence that shows that there was no participation at the county assemblies, just to clear up the point you're trying to make. Thank you.
I think I can follow that up by seeking clarification also from Ms. Kituku on the question of public participation. And we all recognize that there was no legal framework to guide the process of public participation. My question is, in the absence of this legal framework, does the Constitution allow some broad parameters that can be used for public participation? And if so, what are they, and how can they be measured? The other one is also a follow-up, maybe to Dr. Kaminwa, and this is about the basic structure. I'm happy you are now calling it the principle, because I've been wondering in my mind, when does a doctrine become a doctrine of general usage under the common law or under the international law? But now you say even judgments from the Commonwealth can be elevated to the same level as the international law that is applicable in Kenya as per Article 2(5). Those principles are jus cogens, known as jus cogens. I'm wondering, at what stage does a judgment of the court get elevated to that status? What does it go through to be elevated to that status of a principle of general application under the international law? And I'm looking at the case of Kesavananda, which was before our Constitution, and wondering whether it had actually informed our Constitution because of the Preamble, the Article 2, and the Articles 255 to 257, and other articles on human rights. That would be my clarification on that. Judge Wajara.
Thank you, Council, for your submissions, which will go a long way in aiding us to arrive at a reasoned judgment. I seek clarification from Mr. Harvey. Yesterday you consistently appeared to draw a distinction between amendment of the Constitution and alteration of the Constitution. And then you did state that when it came to the Constitution of 2010, the word alteration disappeared. Did it just disappear? Or could it have been the intention of the framers of the Constitution? And why do you think it disappeared? And if it did disappear, independent of the thinking of the framers, how would this court resuscitate it in a constitutionally interpretative manner? Then all of us, I think, have been told about the 4 sequential steps which would then legitimize any intended amendment to the Constitution. And I think, Mr. Harvey, you can again weigh in on this one. The idea of constituent power, where and how do you locate the juridical form of such constituent power. And then finally from me, I go back to ETOPS. Let's get back to ETOPS. I have a feeling it could become a doctrine in future also. So this is then Ms. Angawa and maybe Ms. Kituku. Let us, for purposes of argument, say that Parliament, in conformity with the minimum of the composition of IBC of 3, that Parliament, for the sake of argument, enacts a law to give effect.
Thank you very much, Mr. Lesinko. If I heard you correctly, you said that the Indian Constitution protects eternity clauses from amendment. Where is that law that says so? What are these eternity clauses? Because if you look at Article 368 of the Indian Constitution, Parliament can amend any article of the Constitution, including 368 itself. But there's a procedure set out in 368. Interestingly, in fact, in India, no court can attempt to challenge, can attempt to overturn any amendment by the legislature, including the state legislature. So where do you get this? What are these eternity clauses that you're speaking about that are not amendable? Where do you get that from? Mr. Harvey, in follow-up to the questions by my two colleagues, at paragraph 1289 of Kesavnavanda, the judges are saying the history of India and learning from experiences of other countries have endeavored to make their constitution as precise and as detailed as possible so that one need not depend upon judicial interpretation to make it survive. Correspondingly, they are made flexible so that there is need for amendment can be done. In that context, looking at Article 255, and I borrowed this question from Senior Counsel James Orengo. If indeed Article 255 does not contain clauses that would not require amendment, and that under 255 you can actually amend all the clauses, what other clauses, what other matters, because 255.1 refers to matters, and I'm asking myself the question, under 255, it says if the amendment relates to any of the following matters, then those matters must be taken to a referendum under 255 or 256. Now, what are the matters outside the supremacy of the Constitution, the territory of Kenya, the sovereignty of the people, national values, Bill of Rights, term of office of the President, independence of the judiciary and commissions, functions of Parliament, devolution, and in fact, the provisions of Article 255. What other matters would you foresee as not requiring an amendment through a referendum, to which we must then defer to the primary and constituent power? What sort of matters are we thinking through? So that, because it's not enough to say, let the courts decide. We must understand as judges, as we sit here today, there are certain matters that you're saying are reserved for us. What matters are those in your thinking? Mr. Dasa and Ms. Kituku, the questions have been asked by my colleagues about Article 250 sub Article 1. But I want to reiterate the question by putting it this way. No provision in a constitution like ours is placed in vain. So that I think in answering my colleagues' questions, tell us as a constitutional question, what is the purpose for 250 sub Article 1? I had arguments that IEBC can do some matters administratively. IEBC can do some matters as a matter of constitutional mandate. Now, explain to me what it can do under 250 sub Article 1 with the minimum of 3. Thank you, Chief Justice.
Thank you. I think we'll follow the practice of giving you 3 minutes to respond.
My Lady the Chief Justice, I have 3 questions. They cannot humanly be answered in 3 minutes. I'll suggest I answer them effectively because they are important to this clarification. My Lord Justice Ouko, you've asked, did the High Court or the Court of Appeal provide with exactitude the location of the basic structure doctrine? The answer is yes. And both the High Court and the Court of Appeal said, for you to identify the basic structure, you must look at the history beneath that particular article. Over and above the history, examine the text. Take, for instance, the judiciary. How did it migrate from the judicature to the judiciary? Because before the judiciary, the judicature was a department of the executive. To that extent, therefore, for you to locate the basic structure, you must confine yourself to those 2 fundamental guiding points. I will give you an example. Nelson Harvey here is male, is a human being. He was born whole. To use the Bible verse in Genesis 1, and God looked at him and said, behold, a perfect being. I can lose a limb. I'll be given an artificial limb to make myself better. I can lose my sight. I'll be given glasses to make my sight better. But if you dismember me negatively by separating the limbs, the lower limbs and the torso, I will die. And if I'm to be succeeded, then I'll have to be replaced by somebody else, perhaps Nelson Harvey II. Essentially, that is the best and simplistic understanding of the basic structure. You will not give me a pig's heart to make me whole. I will live for 1 month and die. So I think to that extent that question is satisfactorily answered. Now, the 4 sequential steps, are they located in the Constitution? No, they are not located in the Constitution. Why are they not located in the Constitution? Let me use myself as the example. I was born. I will die. The manner of my death is not known. Perhaps I will die in my sleep. Perhaps, and to use Professor Githu's words, I will be assassinated because in my status I cannot be murdered, I can only be assassinated. Perhaps I'll die of ailment. So you cannot define with exactitude the manner in which the Constitution will end. Therefore, if you see all these constitutions, the 2010, I believe, I'm not being asked to stop. The 2010, the 1969, and the 1963, they do not provide for their manner of end. But when you look at the 2010 Constitution, you will see it repealing the 1969 Constitution. Those 4 sequential steps, you will trace them from the writings of Professor Nubweze. I can categorize them as primordial, as the imperial creation. You cannot find them within the body. Let me give you another example from the Bible. Trace the genealogy of Jesus in the book of Matthew, Luke, or Mark. You will see it sequentially taken back to Joseph, to David, and finally to Abraham and Adam. Beyond Adam, it is the Creator which is outside the being. And it is these basic concepts that must be read into the basic structure, doctrine, etc. And if there is a contradiction that may be introduced into this argument, let's go back to the being. There are 2 principles. One, we came into existence by creation. We'll follow the genealogy up to Adam. The other one, we came here by evolution. Whichever avenue you pursue, you must go back behind the being. And that is what we call the primordial power, insofar as the constituent power is concerned. Now, constitutions are peculiar to France and the United States of America. These are the two countries that said, will henceforth not be governed by an emperor or the King of England, but will formulate a way in which we'll govern ourselves. We'll set up a constitution with three fundamental and the legislature, so that these functions will not be left to a monarch. Dr. Smokin Wanjala, you've asked, how did the word altar disappear? Was it deliberate? And what do we do about it? It is my answer that the disappearance of the word altar was premeditated and deliberate. And if you look at the writings of Professor Nobweze, he says the fundamental changes to the Independence Constitution were permissible because of a flaw in the definition of the word altar. So that flaw has now been corrected. So that you will not graft an antelope on me and you say you have a being. That is the intention of the framers of the Constitution. And the court ought not to resuscitate it. Because if you do resuscitate it, you will have created the mode of death of a constitution. And that is not what the framers of the Constitution intended. We've gone back to tracing the origin of the constituent power. Does it have a juridical form? The Pharisees asked Jesus, when will we know the end of time? We will never know the end of time, but you will see the signs of the end of time. That is what the teacher said. Now, Aaron Ringera has given clarity to this matter in the case of Njoya versus the Attorney General at page 677. This is what he said. Indeed, it is not expressly textualized by the Constitution. And, of course, it need not be. If the makers of the Constitution were to expressly recognize the sovereignty of the people and their constituent power, they will do so only ex abundanti cautela. For instance, I was born here in Kenya. I need not to have an ID or passport, to use the terms of Miguna Miguna, for me to be a Kenyan. The ID and passport is there for formality, and it is from that premise that we must perceive the constituent power. Justice Lenaona, you've referred to the Kesavananda case, and you've asked us to create a clarity of where these other facets of the basic structure reside outside 255(1)A to J. Now, that is the reason as to why they have to be basic. When we were in Musingu, Ongoya went to study power mechanics, and because I didn't have greater qualification when I joined high school, I studied art and design. But there is a dichotomy between a diesel engine and a petrol engine. There is the carburetor and the injector pump. And if you doubt this difference, if you attempt to kick it like a stone, you will not travel. It is as simple as that. Now, what is the foundation of a democratic state? The foundation of a democratic state is based upon the social contract, with the trichotomy of parliament, judiciary, and executive. And if any of those two are fused, then you are obliterating and obscuring that dichotomy. And I can say affirmatively, from my limited learning of the law, that the basic structure must of necessity include the executive, the judiciary, the legislature, and the Bill of Rights. Because for the Englishmen, they said, oh, king, no, you cannot rule us like this. We must have the Magna Carta for us to have terms of engagement. For the French and for the American, they said, we must have a written constitution. And for that, the king will not be the legislative. The king will not be the judiciary. And will have rights, rights that you are not giving us, rights that inhere in us as being. To that extent, therefore, those must be entrenched and respected as the basic structure, which can be discerned outside 255, 1A to J. I believe I've done my part, or if there's a follow-up question.
Yes, you took your time, 9 minutes.
My lady, time is not of essence here. This is a serious enterprise.
Yes.
The Supreme Court only sits once after 5 years to determine an election petition. What is the hurry? Where are we going to?
Yes, thank you.
Good morning. My lady, the Chief Justice, my lady, the Deputy Chief Justice, my lady and my lords, Justices of the Supreme Court. Your Lordship, your Ladyship, Justice of the Supreme Court, Njoki Ndung'u, you have asked, there are express provisions on quorum for Parliament to conduct business for this court to sit. That's at Article 121 and Article 163(2). There is no express provision for quorum of the IEBC and indeed the other independent commissions that are established under Chapter 18, for the basic reason that the Constitution provides for the the commission's minimum and maximum composition. It does not provide a specific number of composition under the Constitution as it does for this court, which is 7, and it does for Parliament and for Senate, because those are specified in the Constitution. Hence, the ability for the drafters of the Constitution to set the quorum as they intended during the drafting. Now, what is the purpose of the minimum and maximum? And I think that is related to the question that has been asked by His Lordship, Dr. Wanjala, and His Lordship, Justice Isaac Lenola. The engine, the two engines that I spoke about, the Constitution and the statute. The Constitution did not specifically provide for the set number of commissioners. It therefore could not provide for the set number in terms of quorum. That is why the Constitution, under 88.5, says that the Commission must operate on the basis of the Constitution and the legislation. And in the legislation, Parliament, in its wisdom, sets the composition as it did, currently at 7. And sets the quorum in the schedule at paragraph 5, whose deletion or repeal or declaration of unconstitutionality is core to the dispute before this court. And I will clarify for my lady, Njoki Ndung'u, Justice of the Supreme Court, that it was not my suggestion, at least not to my recollection, that we need to read quorum into the Constitution. That seems to be the implied suggestion from the submissions of the IEBC, that we should read the minimum of 3 as the implied quorum for the Commission.
We will give you another 3 minutes, but please don't rehearse. We have what you send in the submissions. Just stick to answering the question.
Thank you, my lady. That was the IEBC's submission. Our submission is that you cannot imply quorum based on Article 251, which provides for a minimum of 3. His Lordship Dr. Wanjala asked if Parliament in its wisdom sets the composition as 3, which is the minimum provided for by the Constitution, and sets quorum at 2, I disagree that it could set quorum at 3 because that would be a unanimous decision, and quorum is the minimum number required to make a binding decision. Would that be bad law? If Parliament in its wisdom did that, went through the legislative process, gave an opportunity for public participation, had the views, and did that, and no one challenged that constitution of 3 in a court of law, and there is no decision of the court that finds it to be unconstitutional, then it would stand as good law. But as we speak, the section that provides for the constitution of the commission has not been changed. So quorum cannot be a minority of that set composition. And I would like to end there and bring to this court the current situation. If you were to take the submissions of the IEBC and confirm or put it as the position in law that the quorum can be 3 because the composition can be 3 as set as a minimum in the Constitution, what you will be saying is that the commission, as currently composed by statute, would be bound by a decision of the minimum membership. But what is most important, my ladies and my lords, is that alongside the declaration of unconstitutionality of paragraph 5 of the schedule was a declaration of unconstitutionality of paragraph 7 of the schedule, which said that where a unanimous decision is not reached, then the decision of the majority of the members present and sitting would hold as a decision of the commission. As it is now, therefore, there is a lacuna, if you were to take the arguments of the commission, in the law on that question, so that we are going to a point where 3 commissioners will say our decision can bind the commission, whereas on the other hand, 4 commissioners would say we are the majority, our decision ought to bind the commission. That is the risk that we are at, because the flight went so far away from the flight path with 1 engine and passengers inside it. Do not forget that. I urge this court not to forget that. We will have that situation, and I do not think it is in the realm of imagination, where 3 commissioners will say, we stand, and 4 say, we stand. Thank you.
The Honorable, the Chief Justice, my ladies, my lords, my name is Justice Njiru Nyaga for the 3rd appellant. And for the sake of clarity, Justice is my name, not my title. I will be addressing the questions that have been raised by the Honorable Judges, starting with the question of Lenaola J. as to the purpose of Article 250, sub-article 1, concerning the minimum of 3. Can IEBC do some matters administratively? And the simple answer to that is no. And we wish to seek solace from the decision of the High Court in this matter, where they were explicit that the statute which has been implemented by, has been enacted pursuant to Article 88(5) does not make a distinction between administrative and policy issues. And that is a point of departure from the decision of Biwott, where the Biwott case was saying it is policy issues only. But the High Court distinguished that, and they said that is bad law, and they respectfully departed from that. So our straight answer to that is no. As per the law, they cannot even do administrative issues. To the question by Lady Justice Njoki, what is the purpose of Article 251? In essence, it just defines the composition, the minimum number of members who can compose an independent commission, because it is trite that there is safety in a multitude of councillors. And when you look at the Biwott case, the issue of quorum came up, and it was clearly defined that quorum is the minimum number that is required for a commissioner, for a commission to transact its business. So 251 states the minimum with the Honorable Chief Justice that for Topua, to the question of Justice Smokin Wanjala, if membership is set at 3, and I will be requesting for just a few more minutes so that I also address Oko's, Justice Oko's question. May I proceed? Thank you. Concerning the question by Justice Smokin Wanjala, if membership is set at 3 and the quorum at 3 or is set at 3 or 2, is that bad law? We respectfully submit that that will be bad law, having in mind the important functions that the IBC conducts. And when you look at the letter and the spirit of the Constitution, it will be wrong to have important decisions of great magnitude being transacted by only 2 commissioners. So for that, we will humbly respectfully submit that that will be bad law. Concerning the last question by Honorable Justice Oko, what is the status of the actions that were taken when the IEBC was not quoried? We respectfully submit first that what is before this court is not the matters that were taken by IBC, such as even the composition of the court, or the by-elections. But what is before this honorable court is a question of the amendment of the Constitution. However, that being said, we take solace in the decision of this honorable court in the case of Mary Wamboi Munene versus Peter Gishuki Kingara and 2 others, a 2014 decision, where you are very clear as to the effect of a provision of a statute being declared unconstitutional. It can either be retrospective or prospective. Therefore, in this case, for matters which the court will look at and see that this, if we are to apply them retrospectively, they might have serious implications, the court can respectfully decide to have them be prospective. And therefore, we humbly submit that you do not buy into the suggestion that has been given by the Honorable, the former Attorney General, Professor Muigai, who I greatly respect, that in any such case, the default position ought to be the application is retrospective. And that is what the decision, that was your decision in the case of Mary Wamboi. And allow me just to finish with what Justice Kriegler said. And this is what he mentioned. I'll read that quickly in that decision, which this court rightly quoted. If an act is void, then it is in law nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more ado. Though it's sometimes convenient to have the court to declare it to be so, and every proceeding which is founded on it is also bad and incurably bad. You cannot put something on it and expect it to stay. It will collapse. The default position concerning this matter is that the declaration of an unconstitutional amendment to a statute should be retrospective. And for that reason, paragraph 5 and paragraph 7 of the IBC Act second schedule still apply? I hope that I've addressed the questions.
Yes, we have taken the answer. Ms. Kituku.
I will invite now Mr. Topua.
Thank you, Chief Justice. I will start with the question asked by the Honorable Justice Ouko on what would happen to the actions that have already been undertaken by the IBC when it was not queried. To answer that question, I would suggest and say that the powers of a court to issue a remedy upon a declaration are very varied. A court can suspend the applicability of the unconstitutional invalidity either retrospectively or prospectively. When it does apply it retrospective, it saves those acts that have already been done. When it applies it prospectively, it does cure the gap that would happen between the date of the declaration and the date that Parliament would be ordinarily remedy the invalidity. Therefore, in this case, we would suggest on the first aspect to say, number one, that either we apply it retrospectively or prospectively. The actions on Article 257.4.5 were done after the judgment in the Katiba Institute. So it will not have any effect on this. It will not change the status of that declaration. However, if there was no order that was issued suspending the declaration, a party that is aggrieved by that, if no order of suspension is issued, it means that the declaration, although issued in rem, cannot apply to each and every action that IBC did. A party aggrieved by a particular action that IBC did during that period it was not queried must move the court in order to have that declaration applied in that action that that party is aggrieved with. For example, if a party was aggrieved, on the results of the elections of the president of the Court of Appeal, that party must move the court and have that declaration apply in that case. So I refer the court to maybe the example in the Murwateto case, when this court issued a declaration that the death penalty was unconstitutional. It did not mean that every convict who was on the death law was set free. However, that the lower court or any other judge who sought to apply that reasoning in the Murwateto case had to bring it within the confines of the case that was before them. So it does not entirely apply bracketry, but just to be brought within the ambit. My lady Chief Justice, I think I'll be seeking more time. I have 5 more questions to answer from the members of the bench.
Yes, if you can summarize them to answers, please don't rehearse your submission because we have it. Just zero in on the answer.
Thank you, my Chief Justice.
So we are giving you another 3 minutes.
On the issue of public participation, as was asked by the Chief Justice and Honorable Justice Njoki Ndung'u, I will start by saying public participation is a factual issue. It can only be determined by evidence, whether or not there was public participation. The issue was specifically pleaded in the Third Way Alliance case that there was no public participation. None of the parties in the matter brought any evidence to prove whether there was public participation. In the absence of such evidence, then the court did find that there was no public participation. Although the counties had been sued and processed the bill without public participation, did not participate in the proceedings. So therefore, the obvious conclusion would be, in the absence of any evidence, there was no public participation. The issue of public participation was actually not contested. The IBC did not provide any evidence on the issue that was raised by public participation in the in the Superior Court. On the question by the Chief Justice, how should this public participation look like? Ideally, it would be left to the IBC to determine how best to undertake public participation in line with the law and the regulations that exist. Its own procedures, administrative procedures, provided how IBC would undertake public participation in relation to verification and certification, in relation to signatures and Article 257 form. There are many methods that IBC could have done that. At a minimum, it ought to have perhaps provided the list of the supporters to the popular initiative at every polling station for inspection, so that members can have an opportunity to engage with the list. Number two, it could have also used other media services that are easily available to the members of the public. It could have used print media, all television, the radio station, TV, just to popularize that list. And also, it could have done what the Elections Act says, that's what I've said, through physical inspection of the register. On the question again by Justice Njoki Ndung'u, Justice Wanjala, and Justice Lenaola, on the quorum, on why Article 251 and its importance, I will start by saying that we can't find that answer in the CKLC report. The CKLC on the Constitution, there were concerns that sometimes the commissions could have been too big or they could have been too small. So the idea was to restrict the number of the commissioners. And number two, Chief Justice, I humbly request for 1 minute to wind up. Thank you. To restrict the number or provide Parliament with the leeway to set the appropriate number of members as commissions are different and carry out different constitutional obligations. For example, the Kenya National Human Rights Commission has 5 members set by registration. The National Gender and Equality Commission has 5. The Judicial Service Commission has 11 members. So this is an issue that was left to the Parliament to determine the number of commissioners. So therefore, when Parliament, in its wisdom, which Parliament does not legislate in a vacuum, but Parliament understands and knows the needs of its people, understands its history, when it did set the number of the IBC commissioners as a minimum of 5 and a maximum of 7, it clearly undertook its mandate and understood what it was doing. So that registration that put the number as 5 has not been challenged in this court. It is not on appeal, and we urge the court to find as such. I will associate myself with the submissions made by Mr. Nyaga on the issue of business and policy of the IBC. Thank you.
Thank you, my lady, my lords. Direct the questions. Am I suggesting that this court is bound by the rule of limiting itself to matters of law in case of a second appeal? Yes, that's what I'm submitting, for the following reasons. Article 163 that gives that right of direct appeal, it's a direct of appeal where what is at issue is interpretation or application of the Constitution. In doing that, you employ Article 259 of the Constitution, which provides legal principles. Section 3 of the Act establishing this court, which sets out legal principles. So the matters that you are doing actually application of legal principles to the question at hand, and not an investigation of the facts afresh. Secondly, the case of Munya, which you engaged with this question a little, you found that a second appeal in an election matter can be preferred to this court, because it involves an interpretation and application of the Constitution, but that is limited to questions of law. So I wish I had more time to do further research, but bottom line is, based on that, I'm convinced that we are limited by that rule. Just a brief engagement with the question of the quorum, because I have a bit of time there. It's important to understand the scheme of Article 251. Minimum 3, maximum 9. It's not arbitrary, it's not magical. Parliament cannot just pick 3. It has to engage with the many other factors you find in Article 232 of the Constitution, Article 10 on regional balancing, on gender balancing. So if it just arbitrarily picked a number, then that number can be challenged because of the rule of harmonious reading of the Constitution. Fortunately for us, Parliament in the IEBC case did not pick 3. So to that extent, again, the question of the IEBC must be determined in full light of the numbers that Parliament in fact picked and the statutory arrangements that there were regarding the question of the quorum of the IEBC. My assistant, Mr. Ogada, desires to make some contribution, my Lady Chief Justice. I'll kindly invite you to, I request you to allow him to make a measure of contribution to one of the questions that we thought could have been dealt with better.
We'll give him 3 minutes.
Fair enough.
Thank you, Your Ladyship. The question of public participation, your question was precise. In the absence of legal framework, does the Constitution provide for how to deal with public participation? Article 259, Your Ladyship, Chief Justice, 259.1. Conceptually, that's purposive interpretation. 259.3, a non-living tree reading of the Constitution. Originally, from the case of Edward versus Sankey, Canadian case. Read that together with Article 165.3, which gives original primacy to the High Court, sitting as the Constitutional Court, to interpret the law. What am I saying? The court, the judiciary, has the unique role to give meaning to the abstract provisions of the Constitution, such that when Justice Odunga sits and in expert Egekuru says that these are the parameters, these are the conceptual contours of public participation, the court has exercised its mandate under the Constitution. Quickly, on the question of when does Commonwealth law and international law become part, for purposes of persuasion, our law. Article 2.5 speaks of general rules of international law. Conceptually, that is wrong. It should be general principles of international law. Justice Dr. Wanjala, you have taught international law before. You will bear me witness. Article 38.1, where we get the sources of international law, speaks of general principles of international law. So as a subsidiary source of international law, we will look at the preponderance of decisions from around the world. And when these courts identify certain principles, certain doctrines to be applied robustly or uniformly around the world, then you will be persuaded that humanity has found these principles to apply commonly, and we will adopt them. That's my submission. Thank you.
You have the floor, Dr. Camino.
Yeah, can I speak, my lady? Yeah, thank you. My lady, I have understood your question, but with respect, we are dealing with a specific case, Casavananda case. And it's my humble submission that this case, Casavananda, is taken care of by Article 38 of the Statute of the International Court of Justice, Statute of International Court of Justice, which specifically refers to cases decided by national courts. And there is, this is referred to in page 41, page 41 of Brownlee's Principles of Public International Law, 8th edition, where he says very briefly, if I may read the sentence, Article 38, 1D of the Statute of International Court is not limited to international decisions. Decisions of national courts also have value. Decisions of national courts also have value. And specifically, the question is answered, which you have raised in the little book written by, the title is Unconstitutional Constitutional Amendments. Unconstitutional Constitutional Amendments by Yaniv Rosnai, pages 47 to 70. The basic structure has spread in Asia from India to Bangladesh, to Pakistan, to South Korea, Japan, China, Taiwan, Thailand, Sri Lanka, Malaysia, and Singapore, and in Africa to Kenya, South Africa, Tanzania, and Uganda, although Uganda is not mentioned, but Uganda we have a case there. And then Central and South America, Caribbean, and it's my humble submission that this case or this decision has what we call the qualities of jus cogens. Thank you, my lady. I urge you again respectfully throughout this BBI appeal, let us forget about it and move on to something else in life.
Thank you. Thank you.
My Lord, the Chief Justice, the Deputy Chief Justice, Justices of the Supreme Court, my name is Stopwale Sinko, and I'm here to respond to Justice Isaac Lenaola's question on Article 368 of the Indian Constitution, as read together with the Kesavananda case. And as I understood, his argument was that Article 368 of the Indian Constitution gives Parliament almost what I can call unlimited powers in amending the Constitution. Let me first say that my import and my argument with regard to the Kesavananda case was in relation to the Attorney General argument that the High Court and the Court of Appeal erred in relying on that case, which actually is restricted on parliamentary amendment of the Constitution, is distinguished to the Kenyan current case, which was actually the issue of the referendum by the popular initiative. Let me go back. Just in India, the Golaknath case was the state of Punjab. I think it's a 1967 case. It was first held by the Supreme Court that some of the sections of the Indian Constitution, including fundamental rights, could not be altered. And coming back forward to the Kesavananda case, we have the majority decision read by Chief Justice Sikri saying that Parliament could not use its amending powers to alter or damage the Constitution. That leaves us in a situation where, despite the Constitution really giving unlimited powers to Parliament to amend, the Supreme Court, by all its rights, tends to limit. I think, and this despite references under Article 368 that seeks to oust judicial review. So it was my argument then before this court that the Kesavananda case may not actually be relevant so much to the current appeal under consideration, on the ground that my reading of the High Court decision and the Court of Appeal, the judges were clear, I think under paragraph 172 Superior Court and the majority decision in the Court of Appeal, that the Constitution of Kenya is amendable. No immutable clauses, no eternity clauses, and therefore the argument by the Attorney General cannot stand on that issue because Ours is a and
My lady, can you permit me to say something?
Yes, Dr. Camino.
Yeah. My lady, I have an idea of the extent of the Supreme Court library and even the Court of Appeal library. Now, I have a number of books on this amendability, and I would be prepared to hand them to your registrar should you, any of the members of the court wish to have them. I have a book called Making Constitutions in Deeply Divided Societies. I have another one called An Amendable Constitution. I have another one called Unconstitutional Constitutional Amendments. I have another one called Constitutional Amendments. I have another one called Responding to Imperfection, the Theory and Practice of a Constitutional Amendment. I have another one called 6 Amendments, How and Why We Should Change the Constitution. I have another one called The Foundations and Traditions of Constitutional Amendment.
Thank you for the donation.
I'm prepared to hand them to the court should it be necessary. The registrar can get in touch with me.
Yes, we will borrow them to use and then return to you because we don't want to deplete your library. Subsequently, we will order our own copies if we don't have them in our library.
Your Ladyship, the Chief Justice, the legal team for the second appellant had requested that they do their response first, and the reason that they had requested was that so that whatever time they do not utilize for their response, subject of course to the court's convenience, they have kindly agreed to donate to us.
My Lord the Chief Justice, my Lord the Deputy Chief Justice, and my Lords the Justices of Supreme Court, good afternoon. My name is Justice Munyithia for record. Happy to be before you. My Lord, I was lastly in 2017 on an election petition, and this will be my maiden appearance before you since you were elevated to the office. My Lord, you had given us 25 minutes, and we had 5 minutes left. I'll take 5 minutes to respond to Morara's question, and my colleagues will respond to the other issues. My Lord, this question was raised by Justice Lanola yesterday, and my lead counsel, Professor Gedhu, answered that the answer would be found in the decision of 208J as to whether the question of framing the referendum question was right. We have filed responses to that issue in that, and we have also put our written submissions. I will therefore highlight and say that we oppose that question with only one ground, that this issue was not live for determination. In doing so, my Lord, we realized that there was a definite finding by the High Court, and the Court of Appeal overturned or set that decision on page 8360 of the Record of Appeal. Why do we say that this matter was not ripe for determination? Lord, the only law that we have that governs the referendum in the statute books is the Elections Act, Section 49, Section 50 and Section 51, it is very clear that whenever questions of referendum arise, whenever those questions arise, there is step that must be taken. Now, there is no doubt, and Morara has not responded to this, that the process was stopped when it was still in the National Assembly and some of the county assemblies. It had not moved to the President, who, once he receives the bill, will now forward it back to the IBC to frame the question. So that when we were in the High Court and the Court of Appeal, that question was not live for determination. This court, and many other times, we have had judicial interpretation that the only time a court says of jurisdiction to interpret a matter is when that matter is in dispute and you don't agitate on matters that are likely to happen in the future. So that in raising that issue, or the High Court in trying to determine on that issue, there was speculating in the future what happens. Two, the commission, under Article 248, it's one of the independent commission. Under Article 249, it is not subject to control of any authority. We don't doubt that courts can intervene. But when the High Court is exercising its jurisdiction, one, it cannot exercise jurisdiction that is reserved of the Supreme Court. That is very clear in Article 165(5). Two, even if there was need to seek that supervisory opinion for purposes of that advisory opinion, then the matter can only be referred to by IVC in the Supreme Court on the question of framing. So that when High Court pronounces itself, it would amount, one, entering into the mandate of the IBC in terms of framing the question, and that is rightly pointed out by Justice Toyot. Two, it will be exercising advisory opinion. Now, the other issue that I want to address is, can this court now interfere with the decision of the Court of Appeal as far as this matter is concerned? My Lord, likely put, this court now is exercising appellate jurisdiction under Article 163(4), and therefore, it can only address the question raised. It cannot reserve or become an advisory or give an advisory opinion. So we submit that the questions that came before the court, by the High Court itself, it was wrong because it offended the doctrine of ripeness. The Court of Appeal was right in setting aside that other point. My Lord, you cannot start counting your chicken until they hatch. This is exactly what the High Court was doing. We urge you not to be tempted to move to that. We urge that you uphold the decision by the Court of Appeal on this issue. Thank you very much. I'll invite my colleague.
Good afternoon, my ladies and my lords. In a very quick rejoinder in relation to the question of public participation, I would want to draw, with your permission, the provision, the attention of this court to the provisions of Article 257, Subarticle 4. Reads, my ladies and my lords, that the promoters of a popular initiative shall deliver the draft bill and the supporting signatures to the Independent Electoral and Boundaries Commission, which shall verify that the initiative is supported by at least 1 million registered voters. My ladies and my lords, the reason I draw your attention to that provision is because our appeal is limited to that particular provision. And specifically, the IBC did file an appeal in relation to a very targeted question, a question arising from the finding of, one, the High Court, that the IBC, in applying or interpreting the provisions of Article 257(4), is also called upon to confirm that the promoters of the initiative have conducted public participation. That was the first finding, and we did make reference to paragraph 577 of a decision of the High Court. Again, the second limb of our argument was whether the Court of Appeal was right in interpreting that Article 257(4) to mean that the IEBC should have actually been the one to conduct public participation. My lords and my ladies, our position then, as it is now, is that a true reading of that particular provision cannot yield any of those two meanings. Now, let me get back to the responses that I've had from my learned friends. I've had two justifications. That one, the only two reasons why, in their view, the two findings can hold is that the IBC has time. So that under Article 257(4), there is no time prescribed for it to be able to then forward the bill and the signatures to the county assembly. My ladies and my lords, that, in my very humble view, would be a slanted reading of that particular provision. The second reason they give is that IBC is ordinarily expected to have money. Again, my ladies and my lords, that cannot be the reason we say that that obligation crystallizes on the IBC. It is our submission, my lords and my ladies, that if, like I said yesterday and the day before, the process of constitutional review under Article 257 is incremental, and that it establishes several areas where public participation is to be done. And on this, I got support from my learned friend appearing for Muhuri, that is Council Christine. My ladies and my lords, she agrees with me that Article 196 speaks to how then the county assemblies are supposed to achieve public participation. That is a very important concession. Again, we made submissions and no one has contested it, that Article 94 and 95 provides for how public participation can be achieved. So, my ladies and my lords, that remains our submission, that a true reading of that Article 257(4) cannot yield the two meanings assigned to it by both the High Court and the Court of Appeal. My ladies and my lords, that said, I've also had submission, again from the respondents, which appear in one way or the other to want to expand the scope of our appeal. Our appeal did not touch on the question of verification of signatures. I've had lengthy submissions on that question. Please, my ladies and my lords, it is our submission that that component of the appeal should be disregarded because it does not flow from our appeal. Again, I've had submissions to the effect that the finding that there was no adequate legal framework is an issue that touches on public participation. With respect, my ladies and my lords, that does not flow from our appeal. That said, yesterday I did draw the attention of the court to your locus classicus, the decision in BAT by the CS Health. One of the principles under paragraph 96 of that decision is that every case where public participation is called, and that was this court applying the meaning of public participation that should be ascribed to Article 10, Subarticle 2, that at principle number 8, you say that each case is supposed to be looked at with the peculiarity of the circumstances in issue. It then follows that following that principle, one then does not read public participation in every article of the Constitution. And I'll give two examples. My ladies and my lords, today you sit to interpret and give meaning to this Constitution. That is what we have all come before you to do. Now, in the ordinary balance of the Constitution, one would be tempted to apply the provisions of Article 10, Subarticle 2, in relation to public participation. Would it not be turning logic onto its head to say that then, as you retire to do your judgment on this matter, then we call for public participation? I think that would be stretching the meaning of that particular provision. Second example, the AG, I think under Article 156, is the principal advisor to the government on matters law. Again, when the AG prefers an opinion to, say, His Excellency the President, one would not expect that the AG, in conferring that opinion, must then apply public participation. It is our submission, my ladies and my lords, that is the principle that you provided for under principle number 8 of your decision and authority in BAT versus CS Health. And that being the basis, I would also then want to submit, my ladies and my lords, you don't need any additional legal or statutory framework in relation to that question. My lords, I think that then would respond to the question of public participation, and permit me then to invite my lead counsel, Professor Githu Muigai, to respond to the question of the effect of constitutionality. I'm most obliged.
My Lady Chief Justice, judges of the Supreme Court, I'll be very brief in responding to three main issues. Issue number one is the issue of quorum. It would appear that there is a confusion as to the significance of this matter, which I think needs to be clarified. One group seems to argue the issue of quorum as if it has no consequence, as if a finding of no quorum has no consequence whatsoever, as if it were an academic matter. I think Mr. Justice Ouko, in one of his questions to us, sought to draw out that question of, is there consequence? We have had elections, 50 by-elections. We have had elections of the judge of the president of the Court of Appeal, elections of the justice, JSC's judges, representatives, and so on and so forth. This issue of quorum is not academic. It has consequences. Part of what was sought in the lower court was to find that part of the preparatory process leading to the election we expect in August, in a few months' time, was null and void for lack of quorum. So I want to suggest with the greatest possible respect that your lordships step back, take a deep breath, and worry a little bit about consequence. Number two, a question was raised again by the learned Mr. Justice Ouko. Is there some silence on the part of IEBC as regards the proposals to create constituencies and the compromise that may have on the IEBC's vested mandate? There is no silence. We are not embarrassed at all. We are only saying we appreciate that the Constitution is not cast in stone. Today we have a power. That power is well clarified. And it is a power to be exercised over a long period. But we have a constitutional moment in which the promoters of this bill feel requires a special intervention. That is not unconstitutional. And I'll give you an example, my lords. When we were involved in the post-2007-2008 problem, the Kofi Annan peace process, when we sat down, those who were helping in the background, there was a huge argument whether we could amend the Constitution then, because the Constitution said this is the Constitution of the Republic of Kenya and it stands above all other laws. One group insisted this is the Constitution of the Republic of Kenya and it is to be read alongside the Accord, and the Accord shall have equal force. Some people refused and said, no, you cannot do that. Eventually, that is exactly what we did. And all I'm saying is that there is a constitutional moment that may require a special constitutional intervention in the event that matter came and went, and we thank God for that. And finally, in the United States, for example, right now, there is a huge argument about expanding the Supreme Court. That argument arises because when President Trump was in office, he used that period to pack the court with Republicans. And now the court has swung dangerously to the right. And the Democrats are saying, let's add more judges to, and nobody has said that that is an illegitimate constitutional dialogue, that you cannot change that for any purpose. So it is our very humble submission that we have demonstrated that there was quorum at all material times, that the lack of a specific set of rules setting out quorum did not delegitimate IEBC. In fact, it's a question that cannot lie in the mind of any serious lawyer. You cannot say this constitutional commission is legitimate because to be legitimate it requires only 3 commissioners, but notwithstanding its legitimacy, it can make no decision because there is no law, because there is no law regulating quorum. I thought that most of my colleagues on this side who are championing democracy and the rule of law would remember when in this court we came many times and said, we want to invoke the chapter of the Constitution on the defense of human rights. And the court then said, you cannot do that because the Chief Justice has not made regulations. I thought that is the jurisprudence we left behind us, not the one we are running to embrace. Thank you. I have 8 minutes left. I will donate this to the Honorable the Attorney General, who has the very weighty responsibility of guiding our nation.
My Lady the Chief Justice, my Lords, members of the court, I'm sure Learned Senior Counsel Professor Gidu Muigai appreciates only too well the weight on the Attorney General's shoulders, having been the Attorney General himself. Members of the court, I wish to start the Attorney General's response by taking the opportunity to put on record the filings that the Attorney General has made in this matter. And the Attorney General filed a petition of appeal together with a record of appeal that ran to 47 volumes, both dated the 26th of September last year. The Attorney General has filed a supplementary record of appeal, and that supplementary record of appeal has 3 volumes, and that was filed and dated on the 25th of October last year. The supplementary record of appeal is accompanied by an affidavit sworn by Mr. Kennedy Ogeto, the Solicitor General, and that was filed on the 8th of November last year. The Attorney General has filed written submissions on the 24th of September last year, 24th, I'm sorry, of November last year, and supplementary submissions on the 14th of January this year. A bundle of authorities that run from volume 1 to 26, filed on the 24th of November last year. The Attorney General filed a supplementary bundle of authorities on the 14th of January this year. A further supplementary bundle of authorities also on the 14th of January this year. A case digest in respect of all the authorities that the Attorney General had filed, which was filed on the 24th of November last year. A supplementary case digest filed on the 14th of January this year, and a second supplementary case digest that is filed on the 17th of January this year. In respect of the appeal number 15, petition of appeal number 15 of 2021 before this court by Mr. Morara Omoke, the Attorney General filed grounds of objection to that petition of appeal on the 14th of October last year. The Attorney General wishes to rely on those grounds in opposition to the petition of appeal by Mr. Morara Omoke, and the Attorney General adopts the submissions and the authorities that have been filed in respect of that appeal by the Independent Electoral and Boundaries Commission, the second appellant before you in these matters. Your Ladyship, the Chief Justice, I wish to commence the Attorney General's response. by stating that there is no contradiction in the submissions that have been made by the Attorney General in respect of the important matters of the basic structure and the basic structure doctrine. It is the Attorney General's submission that the basic structure is are the foundational provisions of the Constitution. These are contained in the provisions of the Constitution and are identified as entrenched provisions of the Constitution. And it is the Attorney General's submission, and I will justify later on in my reply, that the basic structure of the Constitution of the Republic of Kenya is contained in Article 255, Subarticle 1 of our Constitution. On the other hand, members of the Court, it is the Attorney General's submission that the basic structure doctrine is an extra-constitutional theory which limits the power of amendment under the Constitution and applies to limit the power of secondary constituent power to amend the Constitution. So that is the difference between basic structure and the basic structure doctrine. Further, it is the Attorney General's position that it is the basic structure doctrine is outside the Constitution, but does not apply to the Constitution of the Republic of Kenya, as the sovereign power to amend the Constitution is contained in Article 1, Subarticle 2 of the Constitution of the Republic of Kenya. We submit that it is that our Constitution does not contemplate the basic structure doctrine. The basic structure of our Constitution is instead protected through the onerous amendment procedure stipulated in Article 255 of the Constitution. Amending the basic structure of the Constitution of Kenya requires approval of the people of Kenya in a referendum. The amending provisions that do not form part of the basic amending provisions that don't form part of the basic structure of the Constitution do not impose any such similar onerous requirements. In respect of why the Attorney General believes that the basic structure of our Constitution is located in Article 255, Subarticle 1, we state that the reason why we state that the basic structure is located in Article 255(1) of the Constitution is the history of the Constitution-making process. In our submissions in chief and in our written submissions, at page 73 of the final report of the CKRC, the people captured the concern, or their concern, as follows. And their concern, and I quote, was how quickly and fundamentally, and I emphasize fundamentally, the Independence Constitution was amended. The report goes on to, this is to be found in volume 13 of our bundle of authorities. At paragraph 75, the CKRC then identified what the people's solution was. It states that a distinction should be made between entrenched and non-entrenched provisions of the Constitution, with a stringent mechanism being put in place for amending the former entrenched provisions. The only justification for entrenchment is the historical context, and this would safeguard the core of the Constitution. Article 255(1) of the Constitution would only require a more stringent mechanism for amending the provisions outlined in Article 255(1) of the Constitution, because these provisions constitute, with tremendous respect, the core and therefore the basic structure of our Constitution. The amendment sought to be restricted by the wrongful application of the basic structure doctrine. We submit flows directly from Article 1.1 and Article 1.2 of the Constitution of the Republic of Kenya. We submit that when your ladyship and the other members of this court retire to consider your decision in this matter, if you take a moment to, whilst keeping an eye on Article 1, Subarticle 2 of the Constitution, go through the provisions of Article 257 of the Constitution, and especially from Article 257, Subarticle 5, you will find that the architecture of Article 257, Subarticle 5, clearly demonstrates that the amendment by popular initiative, and it is that amendment that the basic structure doctrine has been deployed to obstruct, is an amendment by the people of Kenya, and is an amendment by the sovereign. There was very heavy weather made of the distinction between the word amendment and alteration, and I believe it has formed, or it was the basis of one of the questions that was asked by one of the learned judges of this court earlier on this morning. And in response, we submit respectfully that there is no difference between the word amendment and alteration. It is a distinction without a difference. The High Court and the Court of Appeal only dwelt on the dictionary meaning of the word amend. It is our submission that the textual meaning of the word amend does not bring out the true meaning of the word amend as used in Chapter 15 of the Constitution of the Republic of Kenya. 16, I'm sorry, not 15, Chapter 16. The contextual meaning of the word amend, as used in Chapter 16 of the Constitution of the Republic of Kenya, connotes the ability of the sovereign that flows from Article 1.1 and Article 1.2 of the Constitution of the Republic of Kenya to make or unmake anything. That is an accepted ability of the sovereign. That is what sovereignty is. And the word amend is then used with that special meaning in the Constitution to then give the sovereign the ability to make or unmake anything in their Constitution. There is no textual or contextual justification for the importation of the basic structure doctrine into the Constitution of Kenya, despite the express provisions of the Constitution. There was an argument made by, I believe it was 254 Hope, that anything could be implied into the Constitution as long as the Constitution does not prevent it from being implied. We respond to that respectfully by saying that that cannot be the law. There is no justification for importing anything into the Constitution. The Constitution is clear, and it does not then lend itself to the importation of any these principles and doctrines that were imported into it by the High Court and the Court of Appeal. I then wish to respond to what is the source of the President's authority to initiate amendments to the Constitution. At a general level, the President is a citizen like other citizens. He therefore enjoys all the rights and fundamental freedoms of all other citizens. These include equality before the law, the equality before the law, and the right to equal protection and equal benefit of the law, Article 27 of the Constitution. Freedom of conscience, religion, belief, and opinion, Article 32, and freedom of expression, Article 33 of the Constitution. Political rights that include the right to campaign for a cause that is provided for in Article 38. In exercise and pursuance of these rights, the President may and can initiate or support amendments to the Constitution. In any case, as was the case in the present instance, some of the functions of the President provide him with the opportunity to initiate and or support amendments to the Constitution. For instance, Article 131 of the Constitution confers upon the President certain functions, the performance of which may potentially include amending the Constitution. The President may initiate and or support amendments to the Constitution in order to, 1, safeguard the sovereignty of the Republic, 2, promote and enhance the unity of the nation, 3, promote the respect for the diversity of the people and communities of Kenya, and lastly, ensure the protection of human rights and fundamental freedoms and the rule of law. Those we submit are constitutional functions of the President that would of necessity enable him to initiate amendments to the Constitution. The next issue I wish to respond to are the submissions that were made in respect of public participation, and public participation in particular in respect of the process of amendment by popular initiative under Article 257 of the Constitution. I wish to submit that it is the Attorney General's position that Article 257, read in its totality, from sub-article 1 to sub-article 10, is replete with opportunities for public participation. If Article 257 were let to run its course, I submit that public participation would have taken place effectively. I submit with tremendous respect that if it is the court's finding, or if it was the finding of the High Court and the Court of Appeal that public participation did not take place, then the only reason why public participation did not take place is because the course of the process of popular amendment via Article 257 was stopped by the court. If the court gave the process the opportunity to run its course, public participation would have taken place. I wish to respond briefly on the submissions that have been made on the ground of appeal of presidential immunity. And there was a submission that in asserting immunity and claiming political rights, or in asserting absolute immunity and claiming political rights, the President of the Republic of Kenya was trying to have his cake and eat it. In response, I wish to submit that following the Bellevue case that was cited severally by my learned senior Mr. Waweru Gatonye, judges of this court enjoy absolute immunity. It is not lost on any of us that judges of this court have severally commenced proceedings in the High Court and in the Court of Appeal to assert their rights under the Constitution. Absolute immunity does not take away a party's rights under the Constitution. It is not a trade-off. You can have absolute immunity under the Constitution, and your rights remain alive for you to enjoy and assert as you choose to. The absolute immunity extended to the head of state under the Constitution of this Republic, as was submitted by learned counsel who appear for him, is for the purposes of enabling him to discharge his functions as head of state effectively. In respect of the constituency question, we associate ourselves with the submission by Professor Githu Muigai, senior counsel for the IEBC, and that submission is that the contents of a bill to amend the Constitution under Article 257 are beyond the court. And we say so for this reason. I have stated earlier on in my response that the amendment by Article 257, as opposed to the amendment by Article 256, is by the sovereign. It is by Article 257 that the sovereign retained the right to amend their constitution. And I submit in response that the contents of that bill is beyond the court's ability to review or pronounce itself as to its constitutionality. That right or that ability flows from the ability donated by the people of Kenya, or vested by the people of Kenya by the High Court, by Article 165, 3D, Roman 2. I want to give an example, or I want to demonstrate the submission that I have just made. And I wish to refer your lordships to the 6th schedule of the Constitution, and in particular, sections 23 and 24 of the 6th schedule. The 6th schedule forms part of the Constitution. And at section 23, the people of Kenya, when they promulgated this Constitution, created a procedure for the vetting of judges. And they created a procedure for the vetting and removal of judges. Judges who enjoyed security of tenure, judges who held office properly under the previous Constitution. The Constitution, again, at the 6th schedule, at paragraph 24, provided for the retirement of the last Chief Justice under the former Constitution. That Chief Justice held office constitutionally, and if these two provisions were subjected to the scrutiny that the Court of Appeal subjected to the provisions that the people of Kenya had made in the bill, for example, about the judicial ombudsman, then no doubt these two provisions would have been found to be unconstitutional. The point I make is that when the people of Kenya sit to determine the content of their constitution, then they are completely free to determine the content of the bill. The role of the court then is to determine procedural compliance with the provisions of Article 16. Of Chapter 16. And once the court is satisfied that the initiative has complied procedurally with the provisions of Chapter 16, then it leaves the content of the bill to the people of Kenya, to the sovereign, to the owners of the Constitution, to determine what they want to amend and the shape and terrain of their Constitution. That is all I wish to respond, and I wish to yield the rest of my time to my learned senior, Mr. George Orlando, Senior Counsel, who wishes to make a few comments in the time remaining.
Thank you, the Chief Justice, the Deputy Chief Justice, and members of the bench. I have only one issue I wish to clarify, and that is in the context of the 4 sequential steps which were prescribed by the High Court to be undertaken before the primary constituent power can be deemed to have been exercised. It was indicated to you that these 4 sequential steps might have been derived from the book by Professor Nabweze, but the fact is that these were contained in the Constitutional Review Act and an amendment to the Constitution, the repealed Constitution, which led to the constitutional review process. And what the learned judges did without expressly stating so is that they were trying to revert to the original ratification procedure as a basis of legitimizing the process of amendment to the Constitution, having acknowledged that our Constitution is not unamendable. It is. And the issue they were addressing there was how can it be done? And they thought that the best way of doing it is to apply the basic structure doctrine and go back to the process we followed in making the current Constitution. Now, the power of making the Constitution is primordial and is vested on the people, and cannot be restricted or regulated either by law or by a court, as we have purported to do in the decision before the High Court and in this court. The people nevertheless have the right of reserving how they can exercise that power, like they have done in our Constitution by Article 1 and Chapter 16. But even where they do so, that cannot stop them, if they wish, from coming up with another process of amending the Constitution. And in fact, in looking at this, a very useful comment I saw in one of the writings by Professor Rosnay, who has now become a popular figure in this court and in all the proceedings below, in what he called Constitutional Amendment and Fundaments, and he says, but due to its extra-constitutional nature, constituent power cannot be regulated by constitutional procedures. You cannot regulate it. You can provide for it, but you cannot regulate it. But least of all, the court cannot provide for the manner in which constituent power can be exercised. The people can always replace the Constitution via a new constitutional making process that breaks legal continuity. So we have a process now under this Constitution, but that does not stop the people of Kenya from coming up with a different process within which they want to exercise their constituent power. But for the purpose of these proceedings, I would humbly submit that the people have crystallized how, for the moment, they want that constituent power exercised, and it is in the Constitution at Article 1 and Chapter 16, read together with Article 259 and other provisions. Does the court fold its hands when it thinks that there is an interference with the manner, the provisions of the Constitution as far as amendment involving constituent power is exercised? I say no. The court has a role. The IEBC has a role, and the people have a role. The role of the court is to ensure that those strict provisions for exercise of the primary constituent power which have been crystallized in the Constitution are very strictly followed to promote the intentions of the Constitution. And that's why the court is given such wide power under Article 259 to ensure that there is sufficient consultation, there is sufficient discussion, the referendum is carried in a manner that ensures that the people's role in amending the Constitution is carried out. What is happening today is we are being told that should be reserved for the court. But we are from an era, I have not heard anybody saying it, when the court on constitutional matter consistently decided for executive. So if we come up with this process where the Constitution can only be amended through the basic structure doctrine, and you have an executive compliant court, what happens? I would humbly submit that the role of the court is to protect the people and ensure that the process the people have put for amending their Constitution is consistently and holistically followed. Now, there is a question which has also been asked as to who are the constituent power. In my humble submission, the constituent power is crystallized in the Constitution by Article 1 stating that it is the people of Kenya. But the question you ask yourself, who are these people? And Article 257 goes to assist you in identifying those who are through the popular initiative. There are citizens of Kenya who are registered as voters. Those are the people. In America, it is different. In America, it is the Congress of the states. In South Africa, it is the provinces. But in the context of our Constitution, there are the Wanjiku and the Onyango and Omar at the coast. And they have said how, for the moment, they want to exercise their constituent power, and that has to be upheld if we interpret this Constitution holistically. Thank you very much, and we are very grateful for the... sorry, my learned friend, Mr. Kamau, wishes to address you for just a few minutes remaining. Thank you.
My Lady, the Chief Justice, judges of the Supreme Court, I just want to comment on a few matters that were addressed to you earlier today. And the first issue that I want to discuss is regarding the question that was posed by the Chief Justice yesterday regarding the steps that were taken prior to the collection of the signatures in respect of the popular initiative. And the importance of that is this. If you look at the steps that the President was said to have taken, which was setting up the task force and the steering committee, this was done in writing, and there's documentary proof of what he did, meaning that he was acting in the discharge of his official functions. And that activity was found to be valid in the case of Third Way Alliance, which was the judgment of Justice Mativo. It has been referred to very many times, and the High Court upheld the steps that were taken by the President. After that, the President then visibly, everybody saw him, he turned up and signed in support of that initiative. And he was doing that in the discharge of his rights as a registered voter required under Article 257 of the Constitution. And that is the dichotomy that is necessary, that in one aspect, he was discharging his functions under Article 132 of the Constitution. In the other, he was exercising his rights as a registered voter under Article 257, which is entitled to. The important thing is that throughout the submissions that have been made yesterday and some of them today, nobody has said what right there is to limit any of the President's powers under Article 24 of the Constitution. Nobody has justified any limitation on the rights of the President under Article 24 of the Constitution. All my learned friend Mr. Mutuma said is the minute you are appointed as President, you lose some rights. What is the legal basis for that conclusion? No law was cited. The second issue that my ladies and my lords I want to comment about is the comment that was made by Mr. Ogada saying, if you want to add constituencies, where are you going to get the landmass? Very interesting question. I was surprised, very interesting question. My lords, in 2010, there were only 210 constituencies. The people of Kenya increased the number by 80. They did not expand Kenya. It was the same landmass, but they were able to increase the number of constituencies. And I dare say that is why both the High Court and the Court of Appeal have not faulted the power of the people to increase the number of constituencies under Article 89 of the Constitution. And so, my lords, I think it is, I just needed to make that comment because it's an important issue to comment about. Lastly, my lord, this issue of constituencies, I have referred you to the documents that we filed on 14th of January. My learned friend has just referred you to it. There is a report by the IEBC. If you look at the conclusions on that report, the concluding pages, I think it's page 38 or 36, you will notice that the people of Kenya in many memorandum asked for increase in the number of constituencies. Now, the interesting thing is that nobody has disputed the fact that these issues of increase of constituencies and so on, the 74 issues that you are referred to, these came from presentations that were made by the people of Kenya through a process established by the President. It's the people of Kenya who gave their views. Nobody has said that it is not the people of Kenya who said it. And the minute the sovereign have given their views, how that views then translates into the process under Article 257 cannot be faulted. Lastly, my lords, I just also needed to comment on what Mr. Lesenku said about the case I referred to, that when I was asked by his lordship, if from research we are aware of any head of government that has been able to undertake popular initiative. And I referred you to the country that I referred to yesterday. And my lords, you will note that that is the system of government that that country has. There is nothing more superior about the system of government that Kenya has over that of that country. And so the fact that it's a prince that is the head of that country does not take away the fact that he is the head of the country, and that the people voted and approved a process that he initiated. I thank you very much for your patience and for giving me that opportunity. Thank you.
Once again, Honorable Justice of the Supreme Court, thank you for the opportunity to make our closing argument. You've had a lot of arguments before this court, and no party has raised any serious challenge to my appeal. I therefore ask the court to just, looking at that, to see that there is general concurrence before the court among the council that the finding of the High Court on the provision for distinct referendum questions is not a highly contested issue. Before I do my closing argument, I wish to acknowledge the Solicitor General Kennedy Ogeto, with whom I worked for about 3 years and a half after graduating from the University of Nairobi, for his mentorship, and I thank him for his training to always have a strong work ethic, which I think he always practices. Is a man of great work ethic, and I thank him greatly. In terms of a few issues that have arisen, in terms of what the parties presented on my appeal, I would like to ask the court to remember one thing, and one thing only, that when it comes to expression of the sovereignty of the people, there's the key tool that they use to express their sovereignty is through voting. And the referendum is one of the most important tools, which does not happen very often. But when it happens, let the people get the opportunity to carry out a referendum that will reflect their will. And as I argued yesterday, when you look at Article 81 of the Constitution, there are very important principles that have been laid down to determine what is considered to be a free and fair election. A referendum is an election. To determine what is to be considered in a referendum as being free and fair, it has to be neutral, it has to be efficient, it has to be accurate. And we cannot talk about accuracy if we lump up all the amendments in one referendum question. The argument by the IEBC that this question is not ripe, that argument is not well founded in law. As I already demonstrated yesterday, Article 22 of the Constitution has limited the application of the political question doctrine in our country. It has given the people access to the court whenever they feel a threat to the Constitution. When I filed my petition E416 of 2020, I did also file a supplementary affidavit dated February 19th, 2021, which you shall find at volume 33 of my record of appeal at page 49 to 4950, and also at volume 34 of my record of appeal, page 4951 to 4971. If you look keenly through my affidavit, I did demonstrate that there was a threat that we could have a referendum any time if the High Court did not actually make the findings it did when it made its final judgment. I laid down that the IEBC had even prepared a budget for the referendum, and it's very clearly indicated in that affidavit. I ask you to look at it, look at the budgetary estimates for the referendum, all contained in that affidavit. Lastly, in terms of whether this question of multiple referendum questions is actually an alien concept, I would say it is not. It's something very mainstream. Already other courts have declared that, and I'll ask the court to read carefully through our bundle of authorities. I did file 9 volumes of that, and there's a digest as well. There's one of the authorities that will show that in our country already the courts have recognized that even before we came before this court on account of the Amendment Act, the Amendment Bill of 2020. Also, there's the Elections Act, which makes some, though not many provisions, but there's some provisions contained on the conduct of referendum. And when you look at the provisions, our parliamentarians already recognize the need for multiple questions in a referendum. Very finally, Honorable Justices, I just wish to end with a short clarion call to the judges. When we came before the court in 2020, as ordinary citizens, as patriotic citizens of this country, we were saying that there was an attack on our constitution, which we consider to be the bridge that connects all of us as a people, our diversity and even the inequalities that we face. That was the bridge that we built in 2010. And our cry then was that we are seeing an attempt we saw as the Breaking Bridges Initiative. What was going to break the bridge? There are many, many bridges contained in our constitution to protect and establish our rights. And we cried to the court and said, please build a wall around our constitution. And build a wall they did. The High Court built a big, beautiful wall, which the Court of Appeal not only accepted as a great mechanism for our constitution, but went ahead to paint and set up surveillance systems around that wall. All I ask the Supreme Court is that may you find it to be the right thing to do under Article 3 to commission that wall. Thank you.
Thank you very much for those responses. That brings us to the end of the hearing of this case. Did you want to say something?
My lady, the Chief Justice and President of the Supreme Court, my lady, the Deputy Chief Justice, my lady and my lords, I think it will be an abdication of our duty on this side if we didn't make very few remarks as we come to the end of these proceedings, with your permission, my lady. And I just want to thank you, my lady, my other ladies and my lords, for the opportunity that you've given us to argue this very important matter in a very good environment. And I think I speak for all my colleagues in saying that you've conducted these proceedings, my lady, with the utmost professionalism, order, and decorum. I must also acknowledge that on this side, my colleagues have shown exemplary professionalism that really befits appearance before this court, the highest court in the land. You have a heavy burden, my ladies and my lords, as you retire to consider this matter of monumental importance to the people of this country. I know we've had very powerful submissions. In some instances, emotional submissions. But my lady, my other ladies and my lords, we look forward to to the fact that you will do justice to the case before you and that you consider it devoid of any attraction to emotion. And has been indicated by various parties in the course of the hearings, my ladies and my lords, the decision that you will make is one that is going to be with us for posterity.
Thank you very much, Mr. Ogeto. Please don't open the submissions.
I am not
we
repeating the submissions, my lady.
Yes.
Only just to thank you once again, and thank you very much once again. And we hope that the decision that finally comes out of your leaderships and your lordships' hands will be one that Kenyans will have respect for, and that Kenyans will agree with, and that all of us will agree to be bound with. Thank you very much.
Thank you. I only take the vote of thanks. And also on behalf of my colleagues, the justices of the Supreme Court, the registrar, deputy registrar, and the entire Supreme Court staff who have worked very hard on this particular appeals, we want to thank you also most sincerely for your submissions and for your very, very able representation of the various parties that you have represented here, and also for the material that you have shared with us. You have availed a lot of material, including Dr. Kamilwa, who has donated some books. This will all help us reach a just conclusion of the matter. So we are very, very grateful for this, and we are also grateful for the people of Kenya for giving us this opportunity to serve in these positions. Thank you, and have a very nice afternoon. The court will adjourn. The date of the judgment will be given on notice. Thank you.
I just want to seek a clarification. Yesterday, NTV in the prime time news indicated that the judgment will be delivered on 14th of February. I just want to get clarification from the court that directions are not being given in a manner that we are not aware of. Just a clarification.
I do not know where the Nation NTV got the date of 14th of February. I do not want to enter into that. The decision of the judges is that the judgment will be on notice. You'll be given a notice of when the judgment will be delivered.